Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Rausen Pereira. Celebrations broke out on Thursday as the LGBTQ community and others welcomed the Supreme Court judgment decriminalizing consensual gay sex, asserting that the historic verdict granted them a basic human right, but also acknowledging that complete equality was still some distance away. A 5-judge constitution bench of the Supreme Court unanimously decriminalized part of the 158-year-old colonial law under Section 377 of the Indian Penal Code, which criminalizes consensual unnatural sex, prompting joyous tears, hugs and dancing across the country. Activists, members of the LGBTQ community, authors and politicians welcomed the verdict, which also said society cannot dictate a sexual relationship between consenting adults, with many cutting cakes and unfurling the rainbow flag. On this edition of The Big Picture, we will analyze the verdict of the Supreme Court on Section 377 of the IPC. Joining me on the program today are J. Sai Deepak, Advocate of the Supreme Court; Satya Prakash, Legal Editor of the Tribune; Menaka Guruswamy, Advocate of the Petitioners; and we'll also be joined by Rahul Ishwar, author and activist. Thank you to all my guests for joining me on this edition of The Big Picture. Menaka Guruswamy, I'd like to begin with you first. Firstly, congratulations on this verdict and your first reaction, really.
Thank you so much. I think clearly a historic verdict, memorable verdict, a far-reaching verdict, locating this decision, all 4 judgments, 5 justices, grounded this decision in equality, dignity, fraternity, life, liberty and non-discrimination, all core values of the Constitution of India. So truly a big day, I think, for both India as a constitutional democracy as well as LGBT citizens in this country.
All right, J. Sai Deepak, let me bring you into the picture. Now, see, times are changing. The law also has to keep up and change accordingly. After all, it's a British law and over 150 years old.
See, I completely share the sense of celebration of Ms. Guruswamy and everybody else who's been fighting this particular battle for a very long time now. My congratulations to all of them. It's just a bit surprising that it has taken us such a long time to actually arrive at this particular decision. It also actually calls into question our own wisdom in receiving and accepting everything which was imposed upon us by the colonial rulers as sacrosanct. So not just this law, but several other legislations perhaps need revisitation. But I think a start has been made. And it's surprising that the fundamental tenor of the Constitution, which was set on the 26th of January in 1950, is being applied to a Victorian provision for the very first time in this manner in 2018. Perhaps it should have been done earlier. So while I'm completely happy about the fact that the provision has been read down insofar as sex between consenting adults, homosexual adults are concerned, and that it has retained other aspects of it, perhaps this is something that they could have done earlier. The one thing that I've asked myself is, why did things come to such a pass? For the simple reason that this provision need not have been applied in the very first place to consenting homosexual adults, because it's not as if the whole section needs to be struck down. It is capable of being interpreted differently. But the fact that it has had a certain intention at the time of its inception, and coupled with the fact that it's been used in a certain sense, perhaps needed this judgment to clearly say that this shall not be used in this manner henceforth. So I think it's a fantastic decision. The doctrine of progressive realization of rights that the Chief Justice has spoken about, I'd like to see how this particular doctrine plays itself out in other cases, wherever there are religious practices that are involved. So that will be very interesting to watch.
Interesting to watch personally as well, as far as Deepak is concerned, because there's a very important case coming up, the Sabrimala issue. Let's keep that for another day.
Right.
But Satya Prakash, bringing you into the picture. Now, of course, celebrations have erupted. The country is rejoicing. But what part of that country is rejoicing? And is society ready for this decision?
I think the society is ready, and why the Supreme Court waited for so long is the fact that the Supreme Court doesn't have the guts to pronounce such verdicts unless there is a consensus so far as political class is concerned. If you remember, post-2009, after the Delhi High Court decriminalized homosexuality between consenting adults in private, there was not this kind of consensus. In fact, even the government, they had taken contradictory stand in the Delhi High Court. The Home Ministry said it should be decriminalized. The Health Ministry said it should be decriminalized. The Home Ministry said it should be not. And then thereafter, in 2013, the Supreme Court reversed the verdict. Post that, there have been a political consensus. The BJP, the Congress, all the major political parties, even Aam Aadmi Party, they all supported decriminalization of homosexuality. Even RSS supported this. And thereafter, the Supreme Court could gather the courage. I'm saying this because the same Supreme Court reversed the verdict in 2013. And thereafter, the curative petitions were pending. These are fresh set of petitions which were filed, and the Supreme Court chose to entertain. The problem with the Supreme Court is, as an institution, it doesn't have that guts to decide cases purely on the basis of touchstone of constitutional principles. It will look for some kind of excuse somewhere else, and when they get that support, then only they decide. And this is the perfect example of that. There are other cases in which we have talked about, triple talaq case. It was just a matter of chance that the case was decided in favor of petitioners. Otherwise, 3 of the Supreme Court judges in that bench, they were all talking about Quran, and they refused to go into the Constitution. In fact, Justice Kurian Joseph's verdict, it starts with Quran, ends with Quran. I am saying this, using Constitution as touchstone, that should be the principle. Here, all the judges, and unanimously they have delivered a verdict. We are all happy that this has happened. It should have happened. In fact, in 2009, when the Delhi High Court delivered the verdict, it is one of the best verdicts we have read on this. I don't know, because this is a huge verdict we are yet to go through. But wonderfully written verdict by Justice A.P. Shah in Delhi High Court. But then it was reversed, and we have wasted so much time.
Right.
I am saying the Supreme Court should be using just constitutional touchstones and deciding cases. This is important because now they are dealing with cases which were not before the types of cases. Look at, they are dealing with sex-related cases. They are dealing with so many cases relating to religion, where there will be so much pressure and so much talk about religious morality, social morality. The Supreme Court in this case has clearly said,
that's another debate altogether. I'd like to raise it ahead in the program as well. Should the court be interfering in such matters, or should it be the lawmakers really who have to sit and deal with issues like this? Is something that we can discuss. Yeah.
One particular point is, just supposing the lawmakers, they don't come forward to do something. If a citizen's fundamental rights are violated, the courts are supposed to protect those fundamental rights. In this case, they have done it. It's good, but they have delayed it. They have talked about, history owes apology to the LGBT community. I am saying the Supreme Court owes apology to the
strong
LGBT
words
community.
there from...
No, because they were made to wait for such a long time.
Right.
It's a question of fundamental rights, right to equality, right to non-discrimination, right to live with human dignity. And they have been denied that right for such a long time.
Justice delayed is justice denied, is what Satya Prakash is suggesting on the program right now, and saying that, the Supreme Court needs to be more proactive and not wait for feelers. Let me bring in Rahul Ishwar into the picture now. Rahul Ishwar, I'm going to go back to a tweet that you put out today. Disappointed, but have to respect the Supreme Court judgment is what you said. Why is homosexual behavior a deviation, do you think?
There are 2 points, sir. One, there are many shades of opinion regarding homosexual behavior in a believer spectrum or a spiritual spectrum. People like Sri Ravi Shankar ji has gone ahead and accepted it. People like Baba Ramdev ji has gone ahead and stated a very divergent point. So there are 2 things. One, we are never for homophobia, but at the same point of time, we believe that respectful difference of opinion and divergence in this paradigm is definitely being there. For example, even in scientific community, the debate on nature versus nurture on homosexuality is still there. Whether the idea of homosexual orientation by birth is a variant behavior or deviant behavior is still debated. We think it is more of a deviant behavior and not a variant behavior. Absolutely, it shouldn't be called a disease, it shouldn't be called an illness, it shouldn't be called perversion, but at the same point of time, a good majority of people maintain that it's a deviant behavior which needs more discussion to be accepted. Having said that, let us say a loud no to homophobia, no to discrimination. At the same point of time, we feel this entire LGBT debate should be based on sexuality and and not equality, should be based on science and not constitutionality. It is a matter that is pertaining to sexuality, human race, family, culture, ethics, and so many things are there. Yeah, there can be divergent view, but we shouldn't be name calling each other, or we shouldn't be abusing each other, and we should be respectfully differing or having divergence of point of view with each other.
Right.
And I lean to a right cultural spectrum where a huge majority of people, especially our Christian Muslim brothers, because of a more codified Holy Quran and Holy Bible, has much more of an opposition. But
Right.
there was
All right.
a grand meeting of all community leaders.
Rahul
where
Ishwar,
every-
I'm going to just come back to you because there seems to be a problem with the connection there. Of course, you seem to be disappearing from the screen itself. Let me go across now to Menaka Guruswamy. You know, Menaka Guruswamy, what does the judgment mean really for the LGBTQ community? How does it change their lives henceforth?
Well, look, I think, the previous panelist, I would recommend that he reads the decisions, because I think it will clarify for him a lot of his misconceptions on deviance and variation. I think the Supreme Court justices spend a lot of time discussing it, and they do so very knowledgeably with having done a fair amount of research, which clearly your co-panelist has not done so. So I think that's the first point. I think the second point is, you see, there are the court. I think when the court actually comes up with a well thought out decision, when the court actually delivers the kind of erudite and really rigorous judgments as it has, and I'm sure your co-panelists haven't quite read it, then you must in fact give credit and celebrate the court. This idea of, well, it's taken so long, I mean, I know it's taken so long, I've been involved in this fight for a very long time, but this is a country which consists of very long-term fights against injustices. And at this present moment, you have some people's movements and you have the Supreme Court, which is actually weighing in on the side of the Constitution. When the court actually does its job, and it's done it beautifully, then I think it is graceful, gracious, and thoughtful for citizens to actually celebrate the court. So, this kind of sort of, let's say the court has guts or doesn't have guts, I don't think behooves panelists to have that kind of conversation. The conversation you should be, in fact, thinking through, your viewers should be part of, is that what does the judgment say? The judgment locates this very firmly in our Constitution's conceptions of equality and dignity, non-discrimination, that this country is founded on. One of the justices speaks of fraternity, and I think that therefore this is not just about sexual acts, this is about something more. And I think that is the point that the last panelist needs to recognize. I think his misconception is he does not appreciate the Constitution's idea of India. He does not
I don't think we should get personal, Menaka Guruswamy. Let's not get personal.
And,
everyone is
that's really his
entitled. Everyone is entitled to his or her own view, and each one is making his or her own view, and that should be respected at the end of the day.
Your views also need to be well-founded. They need to be located in facts, and they need to be well thought out. That's the point.
Okay.
And that is why, presumably, you have panelists on TV.
All right, getting personal there. Yeah, I think I'm going to let you respond to that.
What she said, that this is time to celebrate. My precise point was the Supreme Court could have done it much earlier. That's it.
Yes, Deepak.
So there are 3 points. So point number 1 is full marks to those people who have persevered. And this is not to sound like a party pooper with respect to those people who finally got justice, who finally secured justice, and people who have helped them secure the justice and who've effectively represented them in court. The point that Mr. Satyaprakash is making, and perhaps what I was making, is slightly different, which is this. If you look at the final conclusions of Justice Indu Malhotra and others also, there are 2 findings, or there are 2 directions with respect to concluded prosecutions and pending matters. So where there are concluded prosecutions and people who have been prosecuted under Section 377, this is a serious problem that it has taken such a long time for this judgment to come about. That's point number 1. There's no running away from it. Nobody is saying that, oh, they shouldn't have done it at all. No, finally they've done it, but there is a fact that there is a delay. Now, why is this important? What is the point that's being made, which is this? Of all the institutions in the country, the institution which believes and is truly the guardian of the Constitution should not wait for a popular wave of opinion before a judgment is passed. it must be in a position, it must have the courage of its conviction to go against the popular tide as well, when it believes that it is absolutely right and is founded its opinion on constitutional morality.
So the constitution has to be the touchstone, is
Exactly.
what you're suggesting.
Therefore, that's exactly the point that was being made. Therefore, the aspect of delay perhaps may be a bit to, let's say, it may be a bit of a bitter point to make at this point of time, but there are other causes which are equally, let's say, they're fraught with delay. So that's point number 2. Point number 3. The one disagreement that I have with the point that Mr. Satyaprakash made in the context of triple talaq and the reference to Quran is just this. When a religious practice is involved, a discussion with respect to the origins of that particular practice and the basis of that practice in the script or the custom of that particular practice or that faith is important in order for it to be tested on the touchstones of constitution, because that is exactly the mandate of the constitution when you have to do justice between the two issues. So there, that particular reference was perhaps necessary. Be that as it may, the point that I still think he is making, and I think he's rightly making so, is if the Supreme Court is ultimately vested with the power to take a decision which nobody else in the country can, for the simple reason that a politician is tied down by popular opinion, by his constituents. The Supreme Court is not. And the Supreme Court has shown in the past that it is capable of activism, and I mean it in a very positive sense and not in a pejorative sense. The euthanasia judgment was a case in point. Right to privacy was a case in point. So therefore, this is one particular judgment where now we have effectively the judgment of the Delhi High Court of 2009 has proven to be a judgment way ahead of its time. That was perhaps the same tone and tenor and spirit that was expected of the Supreme Court when the matter came about in 2013. This is not to say that this judgment is bad or anything. The only point that we are trying to say is this: in matters such as these, particularly when personal liberty is involved and dignity is involved and there is criminal prosecution which is in question, it is perhaps imperative for the Supreme Court to perhaps be the prime mover in shaping the opinion on the touchstone of constitutionality, as opposed to allowing a popular wave to dictate its outcome. I am not saying it is necessarily dictated its outcome. The coincidence is hard to miss.
All right. Let me go across to Rahul Ishwar. Now, Rahul Ishwar, will the people of this country have to change their mindset with the changing times and get accustomed to rulings like this in the near future?
I'm sure intolerance or bigotry or running down another person is never a way to change the mindset. Maybe in victory, many people have become so jubilant that they are slightly intolerant. I can understand that. But having said that, see, look at US. Almost in 40 states, conversion therapy is still legal. There is a popular way of opinion across the world where there is a counter narrative to homosexuality. I'm not saying they are right, but there is a very strong counter opinion which we cannot miss. And there is still considerable amount of debate even in scientific circles. For example, Simon Levy, a world famous researcher and scientist in this aspect, who is an openly gay person, he has went on record to say that I have not yet been successful in finding something like a gay gene. Whether homosexuality is by nature or by nurture is still a very hotly debated question in many scientific circles. More than the constitutionality or the equality aspect, there is a scientific sexuality aspect also in this. For example, Animal Kingdom also shows homosexual behavior, but less than 2 to 3%, which is generally considered a deviant behavior. So there are much more aspects than mere technicality or legality in this aspect. So that's the reason why we are pointing out there is a scientific sexuality aspect, cultural aspect. So be it. But whatever said and done, Supreme Court is the final word. They are the law of the land. We should be respectful. We shouldn't have homophobia. At the same time, intellectual, philosophical and scientific opposition or a counter narrative will still be there, not only in India but across the world. That narrative is something we should respectfully engage with and debate with.
And that's why a coin has two sides. Obviously, there are going to be, different opinions and there are going to be differences as well. Yes, Sai Deepak.
Just to respond to what Mr. Ishwar has said, assume for a moment that his point is correct, that this is indeed a deviant behavior which is not to be found in the majority of the population or the majority of any kind of species. Let's assume that is the case. The point that is to be understood with respect to this judgment in section 377 is this: assuming that it is deviance, for which we still don't have statistics so far conclusively, is deviance meant to be criminalized? That is the question. Particularly when assuming that it's deviant behavior, and if the behavior is conducted between two consenting adults in the privacy of four walls, is it necessary for the state to interfere and to criminalize it and take a position with respect to that? That is the central question with respect to section 377. The science may ask itself whether this is the majority view, this is the minority view, whether what is the size of the sample, whether this is deviant, this is natural or unnatural. That's a different question. But when it comes to the interference of the state through the mechanism of the law, particularly criminal prosecution, should the state have a position on this to the extent of criminalizing a certain attitude and going after people. That is the issue before the Supreme Court.
Right.
The Supreme Court is not undertaking a complete scientific study.
All right. Rahul Ishwar also agrees with you completely. Moving on now. Let's move on. Satya Prakash.
One particular aspect.
Okay. Very quickly and then we move on.
Every immoral act is not necessarily a
See,
criminal
I
act.
think that, I'm sorry,
No, one at a time. I'm going to come to you. Ms. Guruswamy, I'm going to come to you. Let Satya Prakash also have his say because he hasn't said much on the program today. Yeah.
Every immoral act need not be a criminal act. And there is a threshold, unless that threshold is crossed, an immoral act does not become a criminal act. Here, that threshold is not crossed because if somebody, two consenting adults, they are doing something, whatever, within the four walls of their own privacy, the state is, how is the state concerned? So, and this case is all about privacy after the Puttaswamy verdict. So, I am saying to say that it can be deviant or not deviant, it is not for the state to decide. It is between two consenting adults, unless they are going to harm the, there are certain consequences for the public order or the society at large. The state should not be concerned about that. So I'm saying the threshold that makes an immoral act a criminal act, that is never crossed in this case.
All right. Closing comments now. I'm going to begin the closing comments from you, Satya Prakash, on is this verdict going to have any bearings on any of the big verdicts coming up in the next few days?
Well, not next few days, but going by the tone and tenor of the hearing, in the 497 case, adultery case, we expect the court to decriminalize that.
All right. Menaka Guruswamy, closing comments from you.
Yeah, I mean, this case was never just about decriminalization. The whole point of the judgment is that it is not simply located in privacy. I think that's the point your panelists miss. It is located in equality and freedom and expression and life, and therefore it is a fuller conception of citizenship. So this whole conversation around, deviant acts, etc., there isn't an understanding of what this case is about. I mean, I think these are just sound bites. So I think I would recommend again that everyone on the panel read the judgment and read the petitions.
All right. Those were the closing comments as far as Menaka Guruswamy is concerned. She has to be somewhere else. So thank you for joining us on the program. J. Sai Deepak, any bearings on the cases to come?
I'll take the pontificatory statement seriously. As far as the judgment is concerned, I think it effectively says the right to live with dignity and the right to be left alone is perhaps the point it tries to make. Privacy is a necessary element of this particular discussion. The fact that a consenting adult can choose what they wish to do without necessarily affecting public health or public order is something that the judgment recognizes. There may be perhaps 1,000 different angles and a gazillion different perspectives with respect to this judgment. But the question would be, what is the leitmotif? What is the central theme? So perhaps people who are associated with this case are better informed. There's no doubting that at all. But from a third-party standpoint, people who've been following these proceedings with an interest and people who've been reading this is what we have gathered. We are happy to be educated on other aspects.
All right. Rahul Ishwar, have you seen the end as far as this particular issue is concerned, or do you believe that this is going to come up again?
Maybe in the social narrative, yes. Warm regards and congrats to all the activists across the spectrum who I humbly disagree with. The debates may continue, but homophobia is bad, is a position I think we all can come to. And saying no to discrimination is a proud part of our identity. And I hope these cases won't be used by a left liberal progressive in-court lobby to propel their own narrative and politics, because I don't think it should be connected to anything. But saying no to homophobia for me is the essence of this entire verdict, and we should all say no to homophobia.
All right. Yes. So,
just the beginning. Thereafter, there are going to be further petitions recognizing their full citizenship. What Menaka is hinting at is about allowing them to get married, allowing them to have rights of inheritance and whole lot of other rights. So that second round of litigation and the fight, legal or otherwise, that will begin now.
all right. On that note, then we'll call it a wrap on this edition of The Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. With that, it's a wrap. See you again next time.